Aloha and thank you for joining the third webinar in this series on racial equity. Today's program is entitled Civil Rights and Access to Justice. I'd like to thank the organizers of this series, the Judiciary's Committee on Equality and Access to the Courts, including its co-chairs, Judge Rebecca Copeland and Willie Bagasol, Judge Sandra Sims, Justice Sabrina McKenna, and Professor Susan Serrano. I'd also like to acknowledge the co-sponsors, the HSBA Civic Education Committee and its chair, Professor Troy Andrade, and the Judiciary History Center, including its executive director, Matt Matisse, Keahi Davis, and Brianna Govea. Today's discussion of civil rights and access to justice is both timely and significant, especially as we celebrate Black History Month. The struggle for racial justice takes place on many different fronts. In previous discussions, we focused on the criminal justice system and its impact on people of color. Today, we're focusing on the enforcement of civil rights, such as guarantees against discrimination in housing and employment. Both the United States and Hawaii constitutions guarantee the equal protection of the laws, and the Hawaii Constitution further provides that no person shall be denied the enjoyment of the person's civil rights or be discriminated against in the exercise thereof because of race, religion, sex, or ancestry. There are statutory protections as well, both on the federal level and here in Hawaii. But having protections in the law and enforcing them on the ground are two different things. I'm reminded of the late Congresswoman Patsy Takemoto Mink, who faced profound barriers because of race and fought her entire career to tear them down for herself and for others, using the tools of advocacy and legislation. As a young woman, Congresswoman Mink left Hawaii for the University of Nebraska at Lincoln, where she discovered that the university's housing policy segregated white students from students of color, and only white students were permitted to live in the school's dormitories. This was the first battle in Congresswoman Mink's lifelong fight against discrimination. She organized protests, wrote to campus officials and newspapers, and spoke to anyone who would listen. And the university rescinded its discriminatory policy the same year. Later, in 1964, she was the first woman of color elected to the U.S. House of Representatives. She dedicated herself to issues like education, women's rights, and environmental protection. She helped to enact Title IX of the Higher Education Act amendments, which prohibits discrimination on the basis of gender by colleges and educational institutions receiving federal funds. That signature piece of legislation continues to provide opportunities for women and girls across the country. Congresswoman Mink's extraordinary career is a story of resilience and commitment. As professors at the William S. Richardson School of Law wrote in a moving tribute, even when the tide of public opinion was against her, she held steadfast to her beliefs and to her mission. Vindicating civil rights is not easy, and it's often unpopular. It requires a steadfast dedication to the fight for equality and justice. We're fortunate here in Hawaii to have organizations and individual attorneys who are dedicated to that work, and you will be hearing from some of those on the front lines here today. But as hard as they work, and I can assure you they are some of the most dedicated attorneys around, they cannot come close to meeting the need that exists for effective representation and advocacy in protecting civil rights. Back in 2008, the Hawaii Supreme Court recognized the so-called justice gap in our civil justice system and created the Access to Justice Commission as a result. The commission is dedicated to addressing the chronic unmet need for legal services in our community among those who cannot afford an attorney. It has done this by advocating on behalf of legal services providers such as the Legal Aid Society of Hawaii, which is represented here today, encouraging attorneys to volunteer their time pro bono, and by making self-help resources available to those who cannot afford an attorney and must therefore represent themselves in civil cases. I'm very grateful for the leadership of the Commission's current chair, retired Maui Circuit Judge Joseph Cardoza, who will be moderating today's panel. Judge Cardoza has been instrumental in many important initiatives, including the Court Navigator program in our Wailuku Courthouse, where volunteer navigators assist individuals when they come to court without an attorney. Thank you, Judge Cardoza, for moderating our discussion today. It's now my pleasure to introduce our distinguished panelists. We're fortunate to have with us Bill Hosijo, Executive Director of the Hawaii Civil Rights Commission, which has enforcement jurisdiction over Hawaii's laws prohibiting discrimination in employment, housing, public accommodations, and access to state and state-funded services. Also, we have with us Daphne Barbie Wooten, who is the president of the African American Lawyers Association of Hawaii, a longstanding civil rights attorney and recipient of the Hawaii NAACP Lifetime Achievement Award. Next, it's a pleasure to introduce Rebecca Leibowitz. Rebecca is an attorney with the Legal Aid Society of Hawaii's Fair Housing Enforcement Division, which specializes in housing discrimination matters in Hawaii. The Legal Aid Society has been a leader in our access to justice efforts and has been active in planning our state's response to evictions related to the COVID pandemic. Finally, we are fortunate to have with us Dina Scheck, who is the legal director of the Medical Legal Partnership for Children in Hawaii, located at Kalihi Kokua Valley. The partnership seeks to address and improve the social determinants of health that impact child and family well-being by engaging in preventive legal care alongside preventive health care. Dina is also a clinical instructor at the Richardson School of Law, which has been a key partner in our access to justice efforts. Thank you to Judge Cardoza and all of our panelists for participating in today's discussion. And a special thank you to everyone listening for joining in today. I will now ask Judge Cardoza to begin today's discussion. Mahalo and aloha.
Thank you very much, Chief Justice Rechtenwald, for that introduction. Now, before we start, just a little bit of housekeeping. Please remember that nothing said during this presentation should be taken as legal advice, and there is no creation of an attorney-client relationship between yourself and any of the panelists. Also, the panelists will not be able to entertain case-specific questions. Now, mahalo for joining us for this third event in the Racial Equity Series. Today, as Chief Justice Rechtenwald has noted, we turn our attention to civil rights and access to justice. We have four distinguished panelists. To orient the audience to your work, can you please describe what work you do or have done in relation to civil rights and how you see it relating to today's topic on access to justice? Daphne?
Thank you for inviting me. My name is Attorney Daphne Barbie Wooten. I want to wish everybody a happy Black History Month, as well as happy Abraham Lincoln's birthday, which is today. I have been in civil rights all my life. My father was a civil rights attorney. We went on marches and protests. And when I moved to Hawaii, I first started with the Office of Public Defenders, which I absolutely loved, gave me good trial experience. I then went on my own and did civil rights cases. I was appointed to the first Hawaii Civil Rights Commission as a commissioner back in the 1989. Anyways, so after I left the Hawaii Civil Rights Commission, I went on back to private practice. Then I had an appointment, a federal appointment to the Equal Employment Opportunity Commission, known as the EEOC, and I was the first trial attorney in Hawaii, which covered Guam, Saipan, and Samoa, in addition to Hawaii. And that was a lot of fun. And then I went back to private practice, and I've been practicing ever since, doing civil rights law, majority civil rights law. And so this is my experience. Thank you.
Thank you, Daphne. Bill, if you would please share with us.
Thank you, Judge. I've been with the Hawaii Civil Rights Commission serving as the executive director since 1997. Before that, I worked doing primarily immigrant rights work at what was then Naloyo. I guess that's basically it. My background is in public interest law, providing legal services for those who can't afford private attorneys, and in civil rights.
Thank you, Bill. And well, now we'll turn to Rebecca.
Thank you. Good afternoon. My name is Rebecca Leibowitz. I work with the Legal Aid Society of Hawaii in our Fair Housing Enforcement Division, where I am an attorney for legal aid. We represent tenants. At times we represent homeowners in fair housing discrimination cases. We do advocacy before landlords and housing associations. We represent people in cases before the Hawaii Civil Rights Commission and before state and federal court. I look forward to speaking with you all today.
Thank you, Rebecca. And finally, Gina.
Judge Cardoza, it's such an honor to be with all these panelists today. So I run the Medical Legal Partnership. It's a program I started in 2000, our first services were in 2009, and we provide free legal services for families at Kokua-Kalihi Valley Health Center. We have on-site legal advocacy clinics that coincide with the KKV pediatrics clinics. So when families come in for their well child checkups, they can also see a lawyer as part of their healthcare team. And we also draw on our client cases to tackle bigger systemic advocacy and community education. So there are two things that really guide our work. And one is this core value that all people and communities have the right and the capacity to lead themselves. And we also embrace KKV's Health Center motto of neighbors being neighborly to neighbors. And I think it's a very simple motto, but it speaks to our interconnectedness and that we're not just lawyers and clients, but we're neighbors. And on a personal note, this month is also a month that Japanese Americans commemorate the signing of Executive Order 9066. And my mom was actually born a month before Pearl Harbor, and so spent her in Lodi, California, and spent her early childhood growing up in Aurora, Arkansas, and Tule Lake, two concentration camps for Japanese Americans and her family. So I come from a long line of fighting for Japanese American redress and learned a lot from those advocates and scholars and lawyers along the way.
Thank you very much, Dina. I'm now going to turn to you, Daphne. Daphne, given your considerable experience as a civil rights attorney, how do you view the current state of civil rights protection across the nation and in Hawaii? Have changes to public perception around race and the importance of civil rights protections impacted how cases are brought and won in federal courts today?
Thank you, Judge Cardoza. Civil rights in the United States was born out of slavery of African Americans for like 400 years. After the Civil War in 1865, there was the first Civil Rights Act. And if you could show the slide, I have a slide presentation. At any rate, while the slide is being uploaded, I have a list of important acts regarding civil rights in the United States. The Civil Rights Act of 1866 was important, and it prohibited discrimination based on race and color or previous condition of servitude. And then there was the 13th Amendment, which abolished slavery by race. The 14th Amendment, which gave equal protection of the law and the right to due process to all citizens. By the way, this was considered male citizens. Then you have the 15th Amendment, which gave African Americans the right to vote regardless of color, race, or prior servitude. And you had the Civil Rights Act of 1870, which prohibits state and state actors from discriminating, and especially with regards to voting. And then you have the 19th Amendment, which finally allowed women or gave women the right to vote. And despite all of the laws for civil rights had a lot of opposition, and there were a lot of trials and tribulations towards African Americans especially, and women. And so even though we had these Civil Rights Acts in 1870 and we had the amendments, there was still a lot of discrimination in America. There were a lot of protests about the discrimination based on housing, discrimination based on education and employment, which I'm going to focus on is employment. Then in 1954, the United States Supreme Court finally ruled that separate is not equal, that segregation based upon race, color, sex is not equal. And then that was Brown versus Board of Education, which was argued by the future Supreme Court Justice Thurgood Marshall, who's African American and was working with the NAACP legal committee. Then, although again, we had the United States Supreme Court striking down segregation, unfortunately, many states and people decided not to follow Brown versus Board of Education, which led to protests and civil rights protests, marching, much of which Dr. Martin Luther King led, and which resulted in the 1964, 10 years later, Title VI and Title VII, the Civil Rights Act, from which today we now use as a basis for litigation in federal courts. Then moving forward very briefly before I get back to Title VII, we have the Voting Rights Act of 1965, and then the 24th Amendment of the US Constitution, which made poll tax unlawful, so the person can vote without having to pay money, and the Fair Housing Act of 1968. Now, moving back to the Title VII. Title VII is the law with regards to employment discrimination. We have under Title VII, employers cannot discriminate against an employee based on race, color, religion, sex, and national origin. And with regards to race and sex, that includes sex harassment, pregnancy, race includes color, and race harassment as well. So that employers cannot fail to hire, or employers cannot fire or do what's called adverse actions against an employee based on these prohibited bases. With regards to the Hawaii Civil Rights Commission, the laws are much greater in Hawaii and protect more bases. For example, in Hawaii, you can't discriminate on somebody in employment because they are a victim of domestic violence. You cannot discriminate against a person in Hawaii because of arrest and court records. So that is something that's in addition to the federal law. And I want to also add that in addition to Title VII, we have the Americans with Disabilities Act, which prohibits discrimination on the basis of disability, and the Rehabilitation Act, and the Age Discrimination in Employment Act. So I know it's a lot to say in 4 minutes, but that is basically the gist of the civil rights laws, specifically focused on Title VII. Thank you.
Thank you very much, Daphne. Bill, I'm going to turn to you now, and building off of what Daphne has shared from the federal landscape, for some, when we talk about civil rights, people think of slavery, Martin Luther King Jr., the sit-ins, and other events on the continental United States. But Hawaii also has a unique history that directly links us to that past. And your office plays an important role in protecting civil rights in the state today. Please share how you view Hawaii's relationship to the civil rights movements of the past and the role you see your office playing in ensuring the protection of these rights going forward. Bill.
Well, hello, Judge Cardoza. Whenever I give a talk about civil rights, I always point out that Hawaii has a proud civil rights history, a history of our own civil rights movement that paralleled the civil rights movement on the US continent, that transformed the American South and the nation. I do this to remind folks that the civil rights movement is not something that happened a long time ago and far away, but something that we in Hawaii were part of, not just a legacy, but a continuing shared commitment and struggle. Today, I'd like to take a little different approach. Rather than focus on what makes Hawaii's civil rights history and experience unique and distinct from the American civil rights history that Daphne has shared with us, I'd like to talk about what links and connects our civil rights movement to the historic struggle of African Americans against slavery and Jim Crow segregation, and for justice, equality, and dignity. By this, focusing on commonalities rather than differences, we should see and acknowledge that we owe a debt of gratitude to the African American civil rights movement, which brings with it a responsibility going forward. So let's start by taking a look at a bongo. Per the University of Hawaii Center for Labor Education and Research, bongo is a Japanese word for an ID tag made of brass or aluminum that had a number stamped on one side. It was usually worn on a chain around the neck. Bongo came in different shapes. The shape was typically determined by the worker's race. Every Hawaii plantation used the bongo system, which was borrowed from the slave tag system used in the American South before the Civil War. Laborers were required to wear their bongo during working hours. Plantation accounts were kept by bongo number, not by name. Pay, deductions for infractions, store purchases, laundry services, and so forth were all kept in account books under the bongo number system. On payday, workers presented their bongo at the payroll desk. They could not get paid without their bongo. You might ask, is the bongo just an interesting artifact? An ID slave tag that just happened to be imported from the slave South for universal use on Hawaii plantations? The connections run deeper than that. In 1850 Hawaii, the Masters and Servants Act created a contract labor system, a form of indentured servitude. With annexation in 1898, the territory of Hawaii fell under the jurisdiction of US laws. Contract labor under the Masters and Servants Act was prohibited by the Organic Act, which imposed the post-Civil War 13th Amendment prohibition against slavery and peonage. The roots of the civil rights movements in Hawaii and America are found in the struggle against economic systems that exploited labor based on race for profit. Much like the Jim Crow South, Hawaii has a history of race and ancestry-based segregation, dating back to the Kingdom of Hawaii, when a ruling oligarchy brought in foreign laborers to work on plantations. On plantations, occupational stratification was based on race and ethnicity. Ethnic wage scales were the rule. Typically, haole workers were paid the highest wage, followed by part Hawaiians and Portuguese, Chinese, Japanese, and Filipinos. Through World War II, the private sector was largely segregated along lines similar to those imposed on the plantations. Hawaii has similar histories of segregation in housing, with segregated plantation camps. My father was born in Amo'olua, an Okinawan camp outside of Hilo, and segregated neighborhoods reinforced by restrictive racial covenants. Segregation in education, implemented both through exclusive private institutions and the English standard school system, and segregation in private clubs. And it's well known that the Pacific Club refused sitting Hawaii Supreme Court Justice Masaji Morimoto's membership application in 1963 because Asians were excluded from membership. I'd like to call up the next slide on the Hawaii death penalty. Okay. Although nowhere near to the horrible toll that racial violence, lynching, and state executions has exacted on Black and brown men and communities in America, Hawaii also has a history of lynchings. And there are two examples, the Katsu Goto case in Honoka'a and the Joseph Kahahavai killing in the infamous Massey case. And it's worth noting that of 47 men executed in Hawaii between 1827 and 1957, before the abolition of the death penalty, 24 or 51% were Filipino, 10 were Japanese or 21%, and only one was white. This is a historical context that set the stage for the civil rights movement in Hawaii that followed World War II. Much of Hawaii's civil rights movement was directly tied to the progress of organized labor and the ILWU, who in efforts to organize plantation workers won important victories securing the right to vote, the right to assemble and associate, the right to trial by jury of peers, and the rights to free speech and due process. I'd like to take a look at Article 1, Section 5, which Chief Justice Rechtenwald had referred to, made reference to. Article 1, Section 5, first adopted by the Constitutional Convention of 1950 and ratified as what was then Article 1, Section 4, conformed the State Bill of Rights with the U.S. Constitution, with both due process and equal protection provided to all persons. But it goes farther than with its express civil rights protection, as the Chief Justice noted. The 1950 framers included the specific provision that no person be denied enjoyment of the person's civil rights or be discriminated against in the exercise thereof because of race, religion, sex, or ancestry. In doing so, the debates of the Committee of the Whole reflect that the delegates were cognizant that the protection provided exceeded that conferred by the federal Constitution. The delegates debated whether this provision would offend congressional delegates from southern states who would construe the provision as prohibiting anti-miscegenation laws, negatively affecting Hawaii's chances for statehood. The Hawaii delegates to the Constitutional Convention of 1950 were motivated by their collective experience, Hawaii's history of de jure and de facto discrimination, which spawned a commitment to civil rights and a civil rights movement, much like that which would transform the American South and the nation. It is because of that commitment that we have strong state civil rights laws. Like the federal civil rights laws that Daphne introduced, but for the civil rights movement, we would have no civil rights laws to enforce. The Hawaii Civil Rights Commission was established by statutes enacted in 1988 and 89, organized in 1990, and opened its doors in 1991. The intent of the legislature in creating the HCRC was to establish a strong and viable commission with sufficient enforcement powers to effectuate the state's commitment to preserving the civil rights of all individuals. The cornerstone of the HCRC statutory scheme was the establishment of a uniform procedure designed to provide a forum which is accessible to anyone who suffers an act of discrimination. As Daphne explained, the HCRC has enforcement jurisdiction over state civil rights laws prohibiting discrimination in employment, housing, public accommodations, and state-funded services. Under our statutory mandate, the HCRC receives, investigates, conciliates, litigates, and adjudicates complaints of discrimination, providing a uniform procedure for the enforcement of the state's discrimination laws. And as has been discussed, our state civil rights laws have broader and stronger protections in corresponding federal law. We see, and the courts have held that federal law is the floor, not the ceiling. And with that, thank you.
Thank you very much, Bill. Rebecca, I'm going to turn to you now. And as a legal aid staff attorney in the area of fair housing, you are on the front line of these cases and see firsthand that discrimination based on race in the area of housing does exist. Hawaii is fortunate to have nonprofit public interest attorneys who specialize in these cases. Can you share the importance of the work you do, especially in light of the economic pressures that the COVID-19 pandemic has placed on our local communities? During the pandemic, are you seeing new forms of discrimination that could contravene civil protections that people may not even realize exist?
Thank you, Judge Cardoza. I prepared, there are quite a number of questions that we got up front that people wanted to know about housing discrimination, especially during the COVID-19 pandemic. So I've included here a little bit of overview of the type of cases that we see, leading into some of the things that we've seen more recently during the COVID-19 pandemic. And I'll also include some information about how to get in contact with us as well. So just to give an overview, fair housing law protects residents in Hawaii in renting and purchasing housing. It covers individuals almost anywhere they live, including homeless shelters, apartment buildings, and in the buying and renting of condos and single-family homes. Housing free from discrimination makes our neighborhoods strong and diverse. Access to quality, stable housing is important to improving educational opportunities and economic outcomes. Hawaii has a difficult housing market due to cost and availability. We also have significant challenges due to a high number of renters versus owners. Many homeowners in Hawaii may find themselves in situations where they play a role in determining housing opportunities and outcomes for others. For example, renting out a family home or sitting on the board of a homeowners association. It is important for homeowners and tenants alike to understand what constitutes fair housing discrimination and the rights that all people have to live in a home and neighborhood free from discrimination. Homeowners, property managers, and apartment associations, real estate agents, and financial institutions all are precluded from engaging in housing discrimination on the basis of race, color, national origin, ancestry, religion, sex, including sexual orientation, familial status, age, marital status, disability, and HIV infection. A housing provider cannot refuse to rent, cannot treat people differently in the terms and conditions of their housing, or harass people based on their membership in a protected class. And housing discrimination covers a wide variety of situations. So for example, in one case where legal aid assisted in 2018, we were contacted by a person of Chuukese nationality who was denied housing at an affordable rental in the Hawaii Kai area. She applied to live at a large apartment complex with her Section 8 voucher and was told that she and her family were ineligible because they were not US citizens and did not have green cards. As a Chuukese citizen, she has permission to live and work in the United States under the Compact of Free Association. Hawaii is her home, but she didn't have the specific immigration or citizenship status the apartment building thought it was required for her to live there. In fact, the apartment management didn't fully understand why they had such a rule prohibiting our client from living there and pointed back at language they had adopted under a funding agreement with the city and county of Honolulu. After review, the apartment complex determined that they were interpreting the rules incorrectly and that residents should not be excluded based on their citizenship or immigration status, and thus permitting citizens of Palau, the Marshall Islands, and Micronesia to live there. Another area in which legal aid sees a large number of cases is with people with disabilities who are facing discrimination. Often these cases revolve around a person with a disability asking for and being denied a reasonable accommodation to make a change to a practice, policy, or rule in their housing, or to make a modification in or around their housing unit so they can have equal opportunity for use and enjoyment in their housing. Successfully providing accommodations is sometimes very simple, such as a landlord allowing a tenant to have an emotional support animal. Sometimes the requests are a little more complicated and require the housing provider to be attentive, act in good faith, and engaged in the interactive process. When a person with a disability is denied a reasonable accommodation, the results can be catastrophic. The place they call home may no longer be usable or safe for them. When a landlord denies a reasonable accommodation, they can be subject to very significant amounts of liability. In 2018, a plaintiff resident won a $1.7 million judgment against a Maui AOAO in a case involving failure to give permission to make a reasonable modification. Time is limited, so I also wanted to mention some of the work that the fair housing community has done through litigation and advocacy on addressing barriers to housing that lead to discrimination. Guidance from the U.S. Department of Housing and Urban Development and litigation one outside Hawaii has addressed the issue of landlords living using criminal background checks in the rental process. Systemic racial injustice in the criminal system also has negative impacts in equal access to housing. Therefore, landlords using arrest records or using criminal records overbroadly to deny tenants is not permitted. Also, using criminal records or background checks in a disparate manner, treating one tenant differently than another, is discrimination. And because tenants denied for housing do not often have the ability to compare their own experience to others, fair housing organizations such as Legal Aid run programs to conduct housing testing, where we can send testers posing as tenants to rentals to discover where housing discrimination may be occurring. We have gotten a lot of questions about COVID and housing, so I'll address those now and take your questions later as well. As we all know, the pandemic has a drastic impact on many families' income in Hawaii, causing renters to struggle even more so with rent. Hawaii has a very high level of homelessness due in part to a very high housing costs, and the additional economic burden of the pandemic has threatened to increase it significantly. Since April 2020, there has been in effect a state moratorium on evictions for non-payment of rent. There has also been some rental assistance made available for renters and homeowners, but it has fallen short of covering it fell short last year of covering everyone. A new rental assistance package is supposed to be available soon and should allow both tenants and landlords to apply. Meanwhile, the eviction moratorium continues and tenants cannot be evicted for non-payment. But once it lifts, there will be new challenges, especially since the pandemic has had disproportionately impacted our communities and people may face new barriers in equal access to housing. Unfortunately, also since the beginning of the pandemic, we have also seen an increase of harassment in housing cases. Harassment in housing may in fact be housing discrimination. Even a claim of a neighbor harassing another neighbor may result in a housing discrimination claim where the harassment is severe or pervasive and the landlord is in a role to intervene and does not. Sexual harassment in housing is unlawful, as is harassment based on race, national origin, disability, or any other protected class. Many people have also asked whether a tenant can be discriminated against because they have had or are believed to have a diagnosis of COVID-19. Housing providers should not inquire into people's disabilities or medical conditions. There are neutral questions a landlord may ask related to the pandemic that may be valid. Example, before meeting people with someone in person, they may ask if they had been out of state in the last 10 days or had had COVID-related symptoms. Setting rules of tenancy, such as requiring all tenants to wear masks in common areas, is not discriminatory. However, refusing to rent or evicting someone because they have had or have thought to have COVID would be discriminatory. Housing discrimination law protects people from being discriminated based upon their housing provider's perception that they have a disability. Very importantly, anytime a landlord applies a rule differently against one tenant than another based upon their protected class, such as treating men differently from women, tenants of one race differently from another, that is impermissible discrimination. That would apply with COVID-19 as well. For example, a landlord denying housing to someone based on their national origin because they might be statistically more likely to get COVID is discrimination. That's a lot of information in a little bit of time, and more information is always available. The Legal Aid Society of Hawaii, as well as the Hawaii Civil Rights Commission participates in conducting annual trainings open to the public, specifically on fair housing, as well as trainings to individual groups. We at Legal Aid do provide some very limited technical assistance to landlords who can reach us at fairhousing@legalaidhawaii.org. That's fair housing, one word, at legalaidhawaii.org. We also provide legal advice and representation to tenants and homeowners experiencing discrimination. We do not represent landlords or housing providers. Our intake number for someone seeking our services is 808-536-4302. Additionally, if you are an attorney and interested in gaining experience in housing or fair housing law and are looking to contribute pro bono hours or looking for co-counsel potentially on cases, you are welcome to contact us and can contact our main number at 536-4302 or our volunteer hotline at 527-8005.
Thank you very much, Rebecca. And so Dina, I'm going to turn to you now. Dina, the work you do in the community is both legal and policy driven. You have had many successes, such as the recent restoration of federal Medicaid for the Compact of Free Association community. Can you share how the Medical Legal Partnership is uplifting and empowering communities to advocate for civil rights and fair treatment, and the importance of continued community involvement in this way? Dina?
Thank you so much. And I love your choice of words of uplifting and empowering. So I want to add another dimension to the civil rights work here. And so at our Medical Legal Partnership, we do handle civil rights cases in various areas, most often housing accommodations, as well as language access and related rights. But a hallmark of the work that we do is that we engage in systemic advocacy, often drawing on what we learn from our individual client cases. And we work alongside our client communities, often uplifting the advocacy and organizing work that they are already doing. For those maybe law students who are interested, we're drawing on a tradition of community lawyering, and in particular, the landmark work of Gerald Lopez. He wrote a book called Rebellious Lawyering, One Chicano's Vision of Progressive Law Practice. This was back in 1992. It's still kind of our lawyering Bible. Rebellious lawyering is many things, including lawyering against subordination, where lawyers must know how to work with, not only on behalf of the people that you serve. And I'm going to just race through a couple of other references. Another influence is our own professor, Eric Yamamoto. He wrote this fabulous article that is complex, and I work through it as much as I can. Critical Race Praxis, and the subtitle is Race Theory and Political Lawyering Practice in Post-Civil Rights America. And one of the things I just wanted to highlight from it is his examination of bridging the divide between law and on-the-ground racial justice. So he talks about law as it conceives of justice and the disconnect between racial justice as it is experienced by racialized groups. And lately, I've also been thinking a lot about an article by Lani Guinier and Gerald Torres titled Changing the Wind, Notes Towards a Demos Prudence of Law and Social Movements. So demos prudence tackles the notion that not only lawyers and courts, but also social movements of the civil rights era were actually sources of law. So their title, Changing the Wind, comes from this note they have at the beginning from Reverend Jim Wallace, who describes lawmakers walking around with a finger in the air to see which way the wind is blowing, and how, for example, civil rights leaders organized Selma to change the wind that led to the Voting Rights Act. So changing the wind. These are terribly cursory descriptions of these important works, and we'll share the citations later on. But let me just share, well, I had two examples of our work, but I'll start with the Medicaid restoration in case we don't have enough time. So the 11-year fight to restore Medicaid benefits in Hawaii, the 11 years in Hawaii, for Micronesian migrants who are here under the Compact of Free Association is a great example of what my friend and a longtime community organizer, Inocenta San Kiko, she called it recently, this is our community's civil rights movement. Her father, Manuel San, was actually the first named plaintiff in the 2009 lawsuit when the Hawaii first cut Medicaid benefits. For me, it has been an amazing journey of allyship and a recognition of how interconnected our liberation and our well-being is. And much credit for this policy victory rightfully goes to Senator Mazie Hirono, who introduced this to Congress numerous times over the last several years, and many other politicians and diplomats and lawyers who've been essential to this fight. But from my vantage point, it's really the communities themselves who kept the issue alive. It's the social movement that kept it alive. They demanded appropriate language and framing of their stories. We had to push back against the narrative of they cost us this much, and that they're not paying into taxes, which they absolutely are. They organized protests and sit-ins at then Governor Lingle's office. They sign waving events that we were all invited to that were led by Micronesian college students. There's a all-mic basketball and volleyball tournaments tradition in the community where at this time, every match was preceded by health education, petition signing, fundraising for the cause, and meetings where we lawyers would be invited to explain and strategize around the judicial proceedings as their case worked its way up to the Ninth Circuit, and also talking about the legislative process. So she really talked a lot about our community's civil rights movement. And I have a little heads up that she had said now, the next one might be to address policing issues in the community here in Hawaii. If I can take one more minute to share a little about some of the more rebellious lawyering type day-to-day stuff that we do. I've been really fortunate to work with Hawaii Civil Rights Commission over the many years to conduct fair housing and civil rights trainings for and with Micronesian communities also. And we partnered with leaders and Micronesian-led groups, like I was thinking about, like We Are Oceania before it was We Are Oceania, to engage in these Know Your Rights workshops that we ended up later calling advocacy academies to really honor the knowledge and skills that we were exchanging. Our earliest workshops were designed and co-led with the late Dr. Jojo Peter, a highly respected Chuki's uncle, and a scholar and an advocate. And at these workshops, he was always more than an interpreter. During our first presentation together, I remember he repeated my words in English. I was like, I just said that. But he repeated it in plainer English than even I was using. And then he elaborated on discrimination, for which there is no equivalent word or concept in Chuukese, right? So he explained to me, I have to say several sentences to explain what that means. And so we started talking about things, and we started incorporating into the workshops things like that feeling in your gut, right? Because when we would talk about it, we often would hold our stomachs, right? That feeling in your gut as part of our explanation of discrimination. And only then he would interpret it into Chuukese. And then our collaboration, like approaching it this way, established a lot of trust and rapport. And every workshop was followed by these informal and often very intense one-on-one and small group questions. Often Bill and his staff at Civil Rights Commission, as well as folks sometimes from the EEOC and HUD, would be surrounded by people asking questions and sharing their stories. And we were often hosted by other community advocates and service providers who were also then learning about civil rights advocacy. So I just shared those examples as kind of another dimension to civil rights work. Thank you.
Thank you, Dina. Now we'll turn to all our panelists, there have been many initiatives to improve access to justice in Hawaii. We were one of the first states to create an Access to Justice Commission. Our Chief Justice has been nationally recognized for his collaborative approach to access to justice, and vital legal service providers are doing the frontline work either through staff attorneys or pro bono attorneys, such as Legal Aid and the Medical Legal Partnership. Given the importance of the civil protections that guard against discrimination in places such as housing and employment, and the reality that discrimination and violation still exist, and that the legal system plays an important role in addressing these issues, what can we do in the future to strengthen access to justice in the areas of civil rights? Daphne, I'll let you take the first stab at this.
Okay, thank you. Well, in my opinion, I think that there needs to be waivers of filing fees and costs for someone who's been discriminated against, because if you're fired from your job, you don't have income enough to hire a lawyer or to even file in court. And so although we do have in the state and federal forms where you can apply to waive the filing fee, I don't think there's been enough consideration and granting of these waivers of filing fees and costs. I think we need to have a court-appointed civil rights attorneys because a lot of the civil rights attorneys who represent victims of discrimination, our numbers are becoming smaller and smaller. And a lot of times it's an uphill battle. So if you have a court-appointed civil rights attorneys, just like court-appointed criminal defense attorneys, I think that access to justice would be better served. Also, in the state forms, you can actually have a sample complaint of discrimination. In the federal court, they do have a sample complaint of discrimination that people who are representing themselves pro se are able to look at and to file, but we don't have one in the state system. So I think that would be a very good idea to create one, and you can look at the federal form and create one for the state as well. I think that we need to encourage attorneys to file civil rights cases, whether it be pro bono, mentorship. You can call me and call other people. There's NELA, National Employment Lawyers Association here in Hawaii. You can call and ask questions, and I would encourage more attorneys to do that. Also, we need to have civil rights courses and training maybe in the law school, mentorship, and also as far as civil rights cases, access to civil rights cases in the courts, I think the courts need to be a little bit more, not so quick to file dismissals or summary judgments. If there's a question of fact, for example, and an employee says she was sexually harassed and the employer says, no, she wasn't, don't be so quick to just jump to the employer's position and grant summary judgments, because I think majority of the civil rights case, at least in the federal side, courts tend to rule in favor of the employers. It doesn't mean the employee doesn't have a good case. It just means, I think that unfortunately, there's still a bias against victims of discrimination. So those are some of the things I thought about.
Thank you, Daphne. Bill, any response to that question that I asked?
Yeah, I agree with Daphne. There's a real dearth, a shortage of plaintiff side civil rights attorneys working in Hawaii. I've been with the commission since 1997, and the number of attorneys who specialize in civil rights work in employment and housing has not increased. It's probably shrunk over that time. And in the area of fair housing, actually, Rebecca's office is kind of the only game in town. So I think it's something that the law school and the profession should really take a look at. What can be done to, I guess, have young lawyers consider specializing in civil rights work.
Thank you, Bill. Rebecca?
Sure. So following up on that, thank you, Bill. I spoke when I presented a minute ago. I just want to make that invitation for people who might be interested, listening and are interested, either in providing some pro bono assistance, especially as the eviction moratoriums, when they do lift, there's going to be a tremendous amount of people in need. We already see, even though there are those current moratoriums, we already have a very high level of need. Our office is extremely busy, both on landlord-tenant issues and housing discrimination issues, often which coincide together. And so there's plenty of opportunity for pro bono, and there's also opportunity to do some to work together on some litigation. And we need attorneys with experience who may not have experience in fair housing, but do have experience in litigation, who might want to work with us in a co-counsel situation. So please contact us. Our general number is 536-4302. And we can reach our volunteer coordinator at 527-8005.
Thank you, Rebecca. And finally, Gina?
I think I'm going to go a little bit rebellious lawyering again here and share something about that I've been thinking a lot about around policy making, and especially during the legislative session, and how sometimes some of us get frustrated at the disconnects between policy making and what's happening on the ground. And so over the new year, I was just going to share that. And I actually have a second suggestion around book club idea, but I worked on a paper with 9 mostly Micronesian co-authors to document all the amazing Micronesian-led responses to the pandemic over this last year that I think often flew under the radar. So several leaders shared lessons from 2020, and we asked them, what would you want to say to policymakers and government leaders, in particular because of this disconnect? And how could we bridge the divide between policy makers and the affected communities? And again, looking to my friend Innocenta Saunkiku, who's been organizing, in addition to a million other things, weekly Zoom gatherings of Micronesian ministers and community leaders weekly. I'm telling you, they meet every week, whether it's election day or 2 days after Christmas. And her response was immediate. She said, collaboration, collaboration, collaboration. And I really love that. And then similarly, our friend Jendrik Paul, who serves as the president of the Marshallese Community Organization of Hawaii, they're called MCO. And he said, we really need more networking. We need more communication between these communities. But he said, we need networking with a hint of friendship. And I really love this because it perfectly describes the level of trust that's needed. We need to be more than just professional colleagues or talking policy. Especially when lives are at stake, as we've seen in this last year, especially. We need to have that level of trust, that hint of friendship that allows us to be honest about what's working and what's not working, to sometimes just shut up and listen at these community meetings, and to trust that we'll invest the time in each other to find the solutions that work. And again, I think we could look to the Demos Prudence model and look back through civil rights history and see that that is what is needed. And then I also just want to acknowledge how fortunate we are for our judiciary leadership who would host such a thoughtful discussion series on racial equity. Even calling it Confronting Racial Injustice is Powerful. And I was really inspired to read Chief Justice Rectenwald's statement last June that confronted the challenges raised by Black Lives Matter movements and quotes from Dr. Martin Luther King Jr.'s letter from a Birmingham jail. So thank you for that, very inspiring. But I also want to push us a little further and address the need for even more. On this past MLK holiday just a few weeks ago, our dean at the law school, Camille Nelson. She shared an article that she wrote, a 2008 article titled "The Radical King," that calls on us to remember Dr. King as more than his "I have a dream" soundbite. And there's a great quote that she has. She said, so Dean Nelson urges that the radical parts of Dr. King's messages should be reread and reconsidered in light of their contemporary resonance. And I think that's more true today than ever. And many years ago when I was in grad school and post-grad school, I would actually reread Letter from a Birmingham Jail on the MLK holiday. It's very nerdy, I know. But I always thought it would be interesting to do a little discussion because there's so much there that really challenges us to think about how we lawyer, how we organize, how we policy, how we neighbor. I think we could discuss Dr. King's explication of unjust versus just laws he talks about in that letter. And this might lead us to examine and critique today's formal versus actual equality. We could reflect on Dr. King's response to the white moderates who called his protest unwise and untimely, and really challenge ourselves to examine our own privileges and our own actions or inactions. And we could look at how organizing from love is not some sentimental and weak response. And that's what he called that out in his own a speech called Beyond Vietnam. But that organizing from love is actually a legitimate path that has historic and religious and theoretical groundings. So I just envision this whole series of discussions just on Letter from a Birmingham Jail. And I did throw all of these things that I referenced, articles, in a citation list that I think the wonderful organizers are going to make available also. And I kind of feel like if we're brave enough to kind of have these discussions and reach across our traditional roles and our traditional communities that we traditionally talk to and have these difficult discussions, then we can start to realize, Senta urging us for collaboration, 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 and build those necessary relationships that Jendrik calls on us, the networking with a hint of friendship. So that's my hope for moving forward from the rebellious lawyering perspective. Thank you.
Thank you very much, Dina. We now will turn to some questions, and I realize the time is short, but Bill, I have a question here with respect to Article 1, Section 5. What is the difference between race and ancestry?
Okay, I'll give you a short answer, and then maybe when Dina or Daphne can chime in. Race, the easiest way to describe it is it's a classification that it's like being white or black or Asian or Polynesian. It's basically a socioeconomic classification that's been used to justify things like slavery and internment. The difference between race and ancestry is basically where you're from and where your family or ancestors are from. So ancestry includes things like language as a characteristic of where you're from and where your family is from. And the thing with race is that it feels a little squishy because there's an argument that it's a social construct, but it's very real because people suffer consequences of race. So with that, I kick it over, I think, to Daphne and Dina.
Yes, I agree with Bill. For example, an easy example is race, African American, black, being black. Ancestry would be you're from Jamaica, can't understand your accent, so you don't get the job. And it can be perpetrated by someone who is African American because it's based on ancestry. And the same with Asian, the racial category of Asian. Well, as we all know, there's a lot of people who are Asian, but let's say someone who has ancestries in Japan, an employer may discriminate against the Filipino. And so it's not technically, at least in the federal side, race, because one can argue is that they're both Asian, but you have a Japanese American discriminating against Filipino based upon national origin. So that's the best way I can describe it.
Thank you both. I appreciate that. There's another question here, and I'll shorten it up just a bit. Do the panelists support repudiation of the so-called, quote, doctrine of discovery, unquote, that some scholars and commentators have linked to systemic issues? Anyone want to take a stab at that? I can read the entire question. I might. Systemic issues underscored by the Black Lives Matter movement, the climate crisis, the COVID-19 pandemic, and environmental justice issues faced by indigenous communities around the world. If you don't have a position on a repudiation, do you have any comments relative to systemic issues and how they connect to these areas?
Judge, I'm actually not familiar with the doctrine of discovery, and so I apologize for that. I'll look it up. But I did want to kind of address the last part of that question. And I think one of the things that we have to do as civil rights advocates is reconcile civil rights with human rights and the rights of indigenous peoples, native peoples, because too often civil rights theory and rhetoric has been used against native peoples and native rights. Thanks.
Thank you very much, Bill. Appreciate you sharing that. Another a question relates to the fact that racial equity issues often focus on the criminal justice system. However, in the civil justice system, housing, employment, housing, especially during early childhood, can have a significant impact on access to healthcare, educational opportunities, employment, and other areas. It may actually determine whether one will ever have contact with the criminal justice system later in life. In terms of trends in any of these areas, is anyone seeing anything that would impact one's future? Dina, I think you have some thoughts on this subject.
I'm not 100% sure I heard everything correctly, but when you said all these trigger words for me, and I, as I may have mentioned, like I think the next civil rights movement that someone in the Micronesian community was telling me was going to be policing issues, and just having a lot of friends and organizing partners and colleagues who live in the Kalihi area, who are Micronesian, hearing their stories is just, unfortunately, it's not unfamiliar, especially given this last year of racial reckoning. But I think that we have to think really deeply about police encounters, about where people are living and access to everything from healthcare and fresh food, and how that all intersects. I mean, of course, we live in the realm of social determinants of health. We partner with a health center. So of course, they're looking at what we now call health harming legal needs, right? That's the new catchword. But I think policing is becoming an increasingly, it's always been a problem for many years, not always, but for many years in the Micronesian community here in Hawaii. And I think increasingly so, I think sparked in part, people are speaking more in part because this last year, there were a lot of mask violations, police citations that were disproportionately given to Pacific Islanders. And thank goodness for NPR, HPR, and Civil Beat for doing some great investigating, and our local newspapers. And it's very troubling because I've heard a lot of stories about youth getting harassed for really no reason at all. And even one of those police encounters can just do so much immeasurable damage to these kids who, at the same time, there was a kid who had a very negative police encounter that fortunately did not lead to an arrest or anything worse. But at the same time, his auntie was asking me, oh, can we find someone to help him with his FAFSA? Because we're trying to get him to college, right, on a college path. Like, it's heart-wrenching to see that and how deeply those things are interconnected. Not sure if that's the greatest answer, but it's what I see.
Thank you very much, Dean. Does anyone else want to weigh in on this area? All right. I think we're about to reach the close of our program, but just in case during this question and answer series there was something any of our panelists have that said, I wish I could have said this. If there's anything like that, now's a good time to bring it up. Yes, Daphne.
Yes, it's hard to give you the history of civil rights in 4 or 5 or 10 minutes or even an hour, but I did want to mention that there's a difference between federal court and state court. In fact, in Hawaii State Court, for damages, there's no cap, but in federal court, the most you can get is $300,000. And so there have been recent cases, because I've been looking at the trends. And for a jury case in federal court, actually it was a settlement, EEOC versus HMSA based on disability. And there was a settlement of 180,000, which is a little more than half of what the cap is. Whereas in state court the same year, there was a jury verdict of $3.8 million for a race discrimination case, Harris versus Queens Medical Center. And so the trend, at least from my perspective, is to, if you're a lawyer, ask for a jury trial and file in state court and not federal court. So I just wanted to say that.
Thank you, Daphne. Anyone else? All right, well then, okay. We are approaching the end of today's panel. As a reminder to our audience, this program is being recorded and is available for viewing in the future. We are about to display slides with agency contact information for your future use. And for those desiring a PDF of these slides, the PDF version of it will be available shortly after today's program. So you can look for that. And so these slides are now being shown at this time. And this is important contact information, and we really hope it's something that will be of value to you in the future. Thank you. Now, mahalo to each of our distinguished panelists and to our audience for joining us. We have discussed some very important issues that from the earliest moments of childhood can impact a person's path in life. But this is just one part of the journey. We would like to invite you back 2 Fridays from today, February 26th, when we will be discussing implicit bias training and making the most of that training. That panel will be moderated by Louise Ng, partner at Denton's Honolulu office. The panelists will be Justin Levinson, professor of law at the William S. Richardson School of Law, Jamila Jarman, the in-house counsel at Elemental Accelerator, and Keahi Davis, education director at the King Kamehameha V Judiciary History Center. You will need to register separately to attend that session. The registration link is in the chat box, and we hope to see you back then. And I'll close with saying mahalo and aloha.